honor that we welcome our keynote speaker, Professor Dr. Naazima Kamardeen, a distinguished professor and chair of commercial law and head of the Department of Commercial Law at the Faculty of Law, University of Colombo. Professor Kamardeen holds a Doctor of Philosophy from the University of Colombo, a Master of Laws in International Legal Studies from Georgetown University, where ma'am was a Fulbright Scholar, and a Bachelor of Law from the University of Colombo. Ma'am is also an Attorney at Law of the Supreme Court of Sri Lanka. Professor Kamardeen teaches international investment, intellectual property and tax law, with ma'am's work on international trade focusing on the impact of WTO on developing nations. Ma'am is the member of Law Commission of Sri Lanka and the author of 2 acclaimed books, Global Trade and Sri Lanka, Which Way Forward, published in 2016, and Biopiracies, Forgotten Victims, Lessons from Sri Lanka, published in 2019. We are extraordinarily privileged to welcome Professor Dr. Naazima Kamardeen. I would like to invite ma'am to deliver the keynote address on the impact of the WTO on trade in genetics, implications for Sri Lanka and India.
And the Honorary Co-Chairperson, Professor Dr. and also the Organizing Secretary, Mr. Sri, who has been very kind to me throughout all my issues getting here. Am I audible enough?
Yes, ma'am.
Yes,
ma'am.
Right. And I thank you for giving me this opportunity to share my thoughts on this most relevant topic, and also for your gracious hospitality throughout my visit here. At the outset, I would like to clear the air about a commonly held misconception as to what generic drugs are. Many people think that a generic is a low-quality drug and that it is not as effective as a branded drug. According to the US Food and Drug Administration, a generic drug is a medication created to be the same as an already marketed brand name drug in dosage form, safety, strength, route of administration, quality, performance characteristics, and intended use. It is bioequivalent to a branded drug, which means that a generic medicine works in the same way and provides the same clinical benefit as the brand name medicine. A low-quality drug, on the other hand, means exactly that. It's a drug that does not conform to the safety, strength, quality, and performance characteristics that it's intended to, and as a result may cause a worsening of the condition or even death. Therefore, we need to understand that there's a big difference between a generic drug and a low-quality drug. The impact of the World Trade Organization, or WTO, on the generic pharmaceutical industry is by no means a new topic, nor is it one that India in particular was unaware of when it decided to join the WTO. Professor Gantz has also mentioned the impact of India, Brazil, and other large developing nations on discussions in the WTO, and I will touch on a few of those as well. In fact, India, along with Brazil, was one of the most vociferous voices in raising concern about the chilling effect that the WTO's agreement on trade-related aspects of intellectual property, most commonly known as TRIPS, might potentially have on the trade in generics. These 2 nations representing the largest generic drug manufacturing capacities in the developing world. These concerns were originally facilitated in the earlier versions of the TRIPS agreement when it was in draft stage, namely the annual draft and the Dunkel draft, but they were not included into the final version of TRIPS. And no satisfactory explanation was ever forwarded for this deviation. Membership in the WTO brought with it obligations relating to a number of subjects, according to the single undertaking concept represented by the covered agreements of the WTO. This meant that all WTO members were bound by all of the provisions of all of the covered agreements, including the agreement on trade-related aspects of intellectual property rights. This is a marked departure from the UN Treaty Convention style. Article 72 of the TRIPS agreement effectively removes the ability of members to enter reservations to any of its provisions, making all obligations mandatory. Further, the dispute settlement understanding of the WTO provides for complaints to be brought not only for overt violations of any of the provisions of any of the covered agreements or the main WTO document, but even for non-violation or any other situation, provided that the non-violation or situation complained against would nullify or impair the benefits that would have accrued to members. According to Article 27 of TRIPS, members were obligated to give patent protection for products and processes that were new, displayed an inventive step, and were capable of industrial application. Limited exemptions were given for plants and animals and essentially biological processes for their creation, subject to the requirement that some other protection mechanism had to be provided for these as well. In addition, the TRIPS agreement, while allowing an additional 10-year window for countries that did not have the capacity to provide patent protection, mandated that these nations should provide a filing system to reward priority and also should grant exclusive marketing rights for 5 years if no decision had been taken on the patent by then. As an Indian audience, I believe you are only too familiar with the infamous mailbox case filed by the US against India, where India was found to not have given effect to this obligation and had to bring its legislation in line with these requirements. So we could see that from the very outset, the generic drug market in India was a big concern for IP exporting nations. Eventually, India complied with the ruling of the dispute settlement body and drafted patent laws that were compliant with TRIPS. The greatest fear was that the strengthening of patent laws would weaken the generic drug manufacturing sector. However, the result that emerged was very different as we know now. Through various mechanisms such as strategic tie-ups with foreign firms, the promotion of Indian business model that saw companies mature from generic manufacturers to innovators, and through the provision of contract research and manufacturing services, which basically saw Indian companies taking on outsourced work, the Indian pharmaceutical sector emerged victorious and has since positioned itself as a formidable challenge to those of the more developed nations. I shall discuss this point in more detail a little later. The story from Sri Lanka, however, is quite different. In the 1970s, Sri Lanka too wished to develop its pharmaceutical sector, and to that end, Professor Senator Bibile, who pioneered the national drug policy in Sri Lanka, was also looking to develop the manufacturing capacity of the state pharmaceutical sector along the lines of India, by first importing generics to manage local demand, and then looking to reverse engineer drugs on which patents had expired, with the ultimate view to develop the capacity in Sri Lanka. After his death in Africa under mysterious circumstances and the electing in of a pro-capitalist government in 1978, this policy was not pursued, and instead the reliance on imported drugs continued with very little impetus to promote local innovation. India had of course been a major source of medicines for Sri Lanka for many decades. The COVID pandemic was a major reality check for Sri Lanka. In its wake, it was found that medical and pharmaceutical imports rose by 319% in 2021 from the previous year, with 85% of demand for finished pharmaceutical products being met by imports. This meant that governments and families across the country had to rethink their spending priorities, bringing public health policy and household resilience measures into full focus. Expenditure on medical imports rose by 60% and increased valued at $287 million amidst the country's growing fears of depleting foreign reserves and currency crisis. While this amount may not seem too large in an economy such as India, it represents a large amount of foreign reserves for Sri Lanka. In 2022, amidst the shortages of more than 150 drugs, persons admitted to hospitals with seemingly innocuous emergencies were mysteriously pronounced dead, and those requiring surgery wound up in worse off states, all of which were attributed to the quality of drugs administered to the patients. Sri Lankans who were no longer able to afford private health care were confronted with the grim possibility of death by medication administered at an overburdened government hospital that no longer had access to safe medication during a global pandemic. While Sri Lanka was coming into grips with the medicine shortage, depleting foreign reserves, and a worsening currency exchange crisis in 2022, India, Sri Lanka's largest finished pharmaceutical products manufacturing source, was supplying 50% of the island nation's demand, some of which were later purchased through the $1 billion Indian credit line when introduced. The procurement of medicine from India has since come under wider scrutiny in Sri Lanka. A top-level official was arrested over the procurement of less than standard intravenous immunoglobulin, which led to the demands of 3 persons. In June 2023, local media reported the death of a patient undergoing treatment at the Peradeniya Teaching Hospital in the Kandy district after being given the Indian-manufactured anesthetic Bupivacaine. The news sparked concern among locals, especially since the incident came less than 2 months after a pregnant woman was reported dead at the hospital after being given an Indian anesthetic drug. Following the April incident, the Health Ministry suspended the use of that drug. These incidents were reported in the Indian media as well. Dharmalingam Sharma's article in the BMC Journal reports the results of a review performed on withheld and recalled medicines published in the National Medicines Regulatory Authority official website in Sri Lanka between June 2018 and August 2021. This research revealed that a total of 163 defects were identified in 143 defective medicines, among which the most common types of defects were contamination, stability defects, packaging and labeling defects, and active pharmaceutical ingredient defects. Nearly 70% of the recalled and withheld medicines were of Indian origin. In addition, the findings show that some manufacturers were accountable for repetitive withholdings and recalls, which reflects ignorance of good quality control measures and weak regulatory inspections as a violation of good manufacturing practice. In early 2023, activists took this issue to court, and in April that year, the Supreme Court suspended the importation of medicines from a private Indian supplier under the Indian credit line, stating that serious doubts had arisen regarding the quality, safety, and efficacy of the products bought from 2 private Indian companies. The court also granted leave to proceed in the relevant fundamental rights petition filed by Transparency International Sri Lanka against Health Ministry moves to buy medicines from 2 private Indian companies through unsolicited proposals, bypassing regulatory oversights. The court suspended the future importations of pharmaceuticals from one of these companies until the company was able to get an order from the court that quality and safety requirements have been met and the procurement was valid. The court ruled that the 2 consignments already in Sri Lanka could be released for use only after necessary testing and after the NMRA gave its independent assurance of their safety, quality, and efficacy. The case revealed that Health Ministry had attempted to use the Indian credit line to buy drugs from locally unregistered hand-picked Indian companies, bypassing NMRA approval of vetting, citing urgency. One such company had even been blacklisted by Sri Lanka State Pharmaceutical Corporation over questions regarding some batches of medication. Further, it was revealed that the cabinet had been misled that the acquisition of medicines were those approved by NMRA and that there were a number of suppliers, when in fact the procurement pertained to just the one blacklisted company and medicines that were not registered with the NMRA. The controversy did not end there. As recently as September this year, a cabinet proposal submitted by the then Health Minister on the procurement of 37 drugs from India under the Jan Aushadhi scheme was criticized by the National Chamber of Pharmaceutical Manufacturers of Sri Lanka. One of their major concerns is that the proposed imports from India could possibly bypass the NMRA registration process. The Chamber said that it feared that such a bypass could undermine the regulatory framework that is crucial for ensuring drug safety and efficacy in Sri Lanka. With the change in the political scene that was brought about by the recently held presidential elections, it is likely that these projects will be reviewed once again. To address these concerns, the National Chamber of Pharmaceutical Manufacturers of Sri Lanka recommended that all medicines be evaluated and registered by the NMRA and that procurement should prioritize local agents whenever possible. They also suggested implementing a fast-track registration process for small volume products and ensuring adequate lead time for production or imports to manage quality control and logistics. What the foregoing discussion has revealed is that the health and safety issues posed by drugs from India has nothing to do with generics. It has all to do with corruption, lack of accountability, and a disregard for established rules and procedures. The Indian credit line was extended as a mark of goodwill by India during the economic crisis of Sri Lanka. It is unfortunate that the resources supplied through this were badly managed and used to procure low-quality drugs from rogue companies who had already been identified as such. Nonetheless, contrary to the growing public consensus that increased dependency on Indian generic pharmaceuticals has led us here, Sri Lanka, as I noted before, has long sourced more than half of its medicines from India, long before the crisis or the exigencies of the pandemic. If we analyze the current problem in Sri Lanka, which is the issue of low-quality drugs flooding the market and causing risks to human life and health, it is a recent problem. The issue to be examined is whether it is caused by the increased patent protection and subsequent dearth of generics caused by TRIPS. It is also worth exploring whether the dearth of generics has led to lower options for middle and lower income earners. According to a study done by Sunil Sahu, it was found that the TRIPS agreement did in fact cause a reduction in the generic drug market, but that this did not necessitate generic manufacturers being driven out of the market. According to Sahu, these companies adapted to the changing environments by either learning to innovate or by tying in with bigger companies or by engaging in contract research and manufacturing services. It is of course a fact that some smaller companies ceased to exist after they were acquired by the bigger companies, but they did not engage in this activity at a loss. Therefore, in a manner of speaking, the TRIPS agreement did in fact create a more effective and innovative pharmaceutical industry in India. That brings us to the next question. Has TRIPS resulted in increased drug prices in India? According to Sudeep Chowdhury, the requirement to provide patent protection has in fact made drug prices higher than they were in the pre-TRIPS era. One of the key indicators that this assertion is true can be found in Sahu's work, where he asserts that the smaller companies cease to exist. With the concentration of manufacturing in the hands of a few larger companies who have the innovative capacity, it is quite likely that prices would increase. The experience of Sri Lanka in the recent past also confirms this assumption. With the unavailability of lower-priced yet safer generics, the likely result is not that poorer consumers would opt to buy higher-priced drugs, but that they would look for lower-priced drugs. And in the absence of these lower-priced but efficacious generics, they would be attracted to the low-quality drugs, hoping against hope that these would be as effective as the generics they were used to. Therefore, if the Indian drug market is to continue to display the characteristics described above, importing drugs from India would not be a viable option for Sri Lanka in the future, given Sri Lanka's status as a developing nation and the fact that the average Sri Lankan is unable to afford patented drugs directly from developed nations. Therefore, it is important to reevaluate the need for a robust generic drug market, or even the possibility of strengthening the production arm to be able to produce drugs on which the patent has expired, which are still useful in treating many ailments affecting the general public. In this regard, collaborative partnerships that focus on technology transfers between India and Sri Lanka could be mutually beneficial to both nations. In conclusion, I would like to state that access to pharmaceuticals is an extension of the right to life and must be ensured to each and every citizen of our collective nations, regardless of their wealth or social status. To this end, I believe that it is our duty to work towards finding equitable and sustainable solutions so that all persons can live a life of dignity, happiness, and well-being.
sharing your inspiring words with us.